So the steps are that you start with filing an original petition for divorce. That's your request to the court for what it is that you want. It begins the divorce process. And then the divorce process ends with a final decree of divorce. And that's obtained one of two ways, either by an agreement or by final order of the court. So what I usually start with is the end in mind, and I try to draft an agreed final decree, which is what our clients want. Whatever it is that our clients want, we write that up and send it to the other side. If the other side signs it, we're done. If we can't get there, or if there's information that we need, such as financial information, we request that information from the other side. And once we obtain essentially the list of everything that the parties own, then we determine how that's divided, and then we determine what custody times and rights and duties that the parents are going to have regarding the children, and who's going to pay child support, and whether or not spousal maintenance is paid. When we determine all that, we either agree to part of it or all of it, and then write it up into a final decree and get that final decree signed, or we go to a full and final trial and we get the judge to order, and then we write up the final decree based on the judge's order, and then the judge signs that, and that ends the divorce process. The discovery process is the process where we exchange information in between, and that happens between the filing of the original petition and the final decree. If we are going to do things the hard way and have to go to the court route, then we have to formally serve the original petition and any other pleadings or requests, whether it's a restraining order, which is an order that restrains and prevents someone from doing something that they otherwise are legally ordered to be able to do, or a protective order, which is a more serious version of a restraining order that's designed to protect someone's personal safety. We have to serve that to them, and they have to be brought that document by a process server. Then that person would have a certain amount of time to file an answer. Then they file their answer, or if they don't file their answer, then we can get a default judgment. There's a lot of different things that can happen in between. We can take a deposition, which is where we sort of take out the section from the courthouse and instead sit in an office, and we would get to ask questions of any witness for up to 6 hours on the record, and they have to answer all of our questions. And it's done with a court reporter, and they have a lawyer if they have one, sometimes with a videographer, so it's on video. And then we get their testimony, and throughout that process, we are building our case and preparing for a trial. And during that time, we either negotiate a settlement or we have to go to a full and final trial. And as part of one of the negotiation tactics, and what is required prior to final trial, is a process that's called mediation. And what mediation is where our side sits in one room, the other side sits in another room, and a neutral person called a mediator, who is an attorney, walks back and forth and tries to get a deal done. And if we get a deal done, we sign what's called a mediated settlement agreement, and that deal is locked in stone, irrevocable. And from that, then we write up the final decree and get both sides to sign it, and then put that into the court. So one way or the other, we're either going to come to an agreement, or the judge is going to decide for the parties. You cannot prevent a divorce from happening. If one of the sides wants it, slavery is illegal, and you're able to get out of that divorce. You can't force the other side to be in it. You can do some things to delay it, but it's only going to wind up costing everybody more money and heartache. What we try and do is get our clients through the divorce process in the healthiest way possible, so that they can get from where they are now to where it is that they want to be. In Texas, the divorce process usually takes, if you're done in less than 6 months, that's good. 3 to 9 months is what typically is where our firm averages. If you're going more than 9 months, you're probably in a pretty hard divorce, and you're probably preparing and going to have trial. We've had divorce cases that can last for years. That's unusual. The courts are incentivized now to not let them go on that long, but sometimes they do. Other times, the minimum amount of time that a divorce has to be on file is 60 days. So if today is day 0, and we file the petition today, tomorrow is day 1, and then on day 61, a judge can sign an agreed final decree of divorce, or they can do what's called a default divorce. If someone was formally served and they didn't file an answer in time, then on day 61, the judge can sign an order. So 61 days is usually the minimum amount of time. If we come to an agreement within the 61-day period, then the parties can sign that agreement. It's basically a done deal as a contract, and then we just submit it to the court and wait till the 61st day, and then the judge can sign the agreement. And we get a lot of them done in that amount of time. That's how we want all of them to go. But typically, 3 to 6 months is kind of our sweet spot for a good soft divorce. The minimum thing in order to get a divorce done is a final decree. You have to both sign a final decree in order to get that done. And when the final decree is signed by both parties, or more importantly by the judge, because sometimes one of the parties doesn't have to sign if you're doing a default, then as soon as the judge signs a final decree, then the divorce is over. There are other documents that you need in order to be able to complete a final decree. For example, in order to determine what property is to be divided, you have to know what property exists in order for you to divide it. We have to do what's called an inventory and appraisement, which is basically a list of the property and then the values of each of the items that are on the list. And from that, then we know what exists. And then we will create a spreadsheet that we call a property division spreadsheet that has all the property listed, and that way we can move it and back and forth and see if they take this, they take this, they take this, they take this, what do those columns add up to, and what's the percentage of division in the spreadsheet. So we use a spreadsheet like that as a tool, but the minimum that has to be filed is an agreed final decree of divorce. Divorces vary greatly in cost. It depends on the amount of argument, the amount of work that needs to be done in order for us to determine what property exists, how we're going to divide that property, what the child custody provisions are going to be, whether there's child support or not, and whether there's spousal maintenance. So that can be a process that can cost just a few $1,000s to a process that can cost in the millions of dollars. It really can depend on how much money is at stake. If we're fighting over a 9-figure case over $100 million or more dollars, for it to cost $1 million as a percentage, 1 or 2%. I mean, if you think about it, realtors charge you 3%. If you're going to sell a $100 million piece of property, you're going to pay 3% to 2 realtors and about 2 to 3% in closing costs. A divorce almost always costs less than what a realtor commission would be on the same amount of magnitude of the problem. But who's more important, your realtor or your lawyer? The legal fees in order to do that amount of work, sometimes you have a detective, but surprisingly less often than you would think. Most people think, every divorce has a detective. Actually, it's more rare than anything. The vast majority of all cases don't have any kind of detective that you have to hire. Sometimes you have court reporters and videographers for if you're taking depositions. You'll have document fees about if we have to buy bank records. If we subpoena bank records, we have to pay the bank for those. And sometimes there's like anywhere from $8 to $20 per monthly statement. It just depends. Sometimes they're free, but sometimes documents can start to get expensive for collecting those documents. Sometimes we have business valuation experts or other experts, child custody evaluation. So outside professionals can be additional costs and things like that. Our average divorce case, firm-wise, is the vast majority of them come in between $7,500 and $20,000. But a high net worth divorce, you look at those more as a percentage, maybe 1% worth of the net worth of the problem. People with high net worths, you're probably paying your financial advisors more than you're going to wind up paying your divorce attorney if you hire the right divorce attorney and if things go well. Of course, your spouse gets a vote in how much that costs. The more fighting that there is, the more expensive that everything is. The more work and things that we have to go through. If we have to go to emergency hearing after emergency hearing, if they're not following court orders and we have to do enforcements, and if we have to force them to produce documents, if we have to subpoena documents rather than request them, things like that increase your costs. The more we have to prepare for contested hearings, that's a major expense on attorney's fees. A lot of times we avoid hearings, but we don't avoid them until minutes before we're going to walk in, or sometimes in the hallway or the vestibule right before we're about to walk in and have the hearing. So we've had to do all the preparation. Sometimes it's actually more expensive for us to settle a case than it would have been to try it, because we had to do all the preparation for trying it. And then rather than going in and having a 1-hour hearing, we're standing at the courthouse negotiating for 8 hours. We get better results that way, but cost-wise, it can be a bit of a factor. But most of the time, especially for high net worth, the legal fees are not the issue. The results are much more important. And if we go through the energy and the work in order to prepare properly, there's a good expression is the best way to avoid having to go to court is to be perfectly prepared for court. So preparation is key, and knowing the case, very, very important, and focusing to get you from where you are now to where it is that you want to be in the healthiest way possible. That's the key.